Hi, everybody, and welcome to Topics and Decisions in Patent Law. I'm Joe Murphy.
I'm Reza Mollaaghababa.
I'm Reza Sadr.
So today we have a really interesting case, this Amarin Pharma versus Hikma Pharmaceuticals case. And Amarin is the name brand manufacturer of a drug called Vascepa, which is one of those omega-3 fatty acids for lowering triglyceride levels. Basically, it's fish oil that's been highly purified. Hikma is a generic manufacturer. Um, in this particular case, this is not the typical ANDA litigation, and we're going to discuss a little bit what ANDA litigation is all about. This is actually an induced infringement case, and it's at an early stage in the case because it's under what's called a Rule 12b6 motion. So we'll discuss all that in detail going forward. As part of our discussion, we're going to be discussing labels. And so I want to bring up the label for Vascepa. So when a name brand manufacturer gets a drug approved, part of the approval is that they have to write a label. It can go on for quite a few pages, but there's a section that will list the indications and usage. And for Vascepa, we've got, and I bring up the label here, and you can see that there's actually two indications that I've highlighted here. We've got Vascepa as an adjunct to maximally tolerated statin therapy to reduce risk of myocardial infarction, and the court will call that a CV risk. And there's a second indication as an adjunct to diet to reduce triglyceride levels in adult patients with severe hypertriglyceridemia. In the so-called skinny label case, what a generic manufacturer can do when they propose their label, if one of the indications is covered by patents, and the other one is not, they can actually line through the patent covered indication and certify to the FDA that, okay, the generic manufacturer is only going to market it for this other indication, or it's only indicated for this non-patented indication. So with that, I think I'm going to turn it over to Reza M, who's going to discuss the procedural posture of the case a little bit.
Thank you, Joe. So Amarin sued Hikma in November 2020, and the allegation was that Hikma had induced infringement of Amarin's patent by marketing and press releases. Initially, the case was referred to a magistrate judge who recommended that Hikma's motion to dismiss be denied. I'm sorry, I forgot to mention that Hikma had filed a motion to dismiss, and the magistrate judge recommended initially that the Hikma's motion to dismiss be denied. On de novo review, the district court judge declined to adopt magistrate's recommendation and in fact granted Hikma's motion to dismiss. And Reza S. will talk a little bit more about this sort of so-called motion to dismiss 12b6 motion. It's, of course, at a very early stage of the proceeding. And at this stage, there hasn't really been any fact finding. So one has to make a very strong legal case that the plaintiff really has no case as a matter of law. But the district court judge, in fact, granted that motion that even if you take everything that Amarin says as fact, there was no legal case here for Amarin. But Amarin appealed the district court's decision to Court of Appeal, CAFC, and as Joe will discuss later, CAFC actually reversed the district court's decision and said that granting Hikma's motion to dismiss was not correct. So before we get to the details of those proceedings, I'm going to turn it over to Reza S., who's going to talk about the claims at issue and talk a little bit about the law of motion to dismiss. Reza?
Thank you, Reza. So, let's start by taking a quick look at claims at issue because it's relevant to what Joe also said previously. Here are two examples of two of the patents that are in play here. These are, first of all, method claims to begin with. They're not towards any product because the product is not patentable at this stage, but these are method of use. And in particular, as you see, they cover one of the two indications that Joe mentioned. This is about use of the drug in relation to cardiovascular diseases. One method talks about reducing occurrence of a cardiovascular event in a specific type of patients by identifying a patient which has that triglyceride at some specific level, and administering the drug to them. The other one is about reducing the risk of cardiovascular death, again by administering the drug. These are all both related to the CV, cardiovascular diseases, which was one of the two indications that Joe mentioned, and these are patented. There was another patent which was deemed invalidated, and that relates to the other usage, other indication, as the quote here from the opinion shows, and thus that's the one that the generic manufacturer can direct the usage of their generic drug towards. So going forward, in terms of the law and the procedure, here we see a very brief summary of induced infringement, which is the legal theory here. It is codified in 35 USC 271 about infringement. Subsection A is, of course, about the direct infringement, but here we are dealing with subsection B, an indirect infringement, and in particular, the induced infringement, which just states whoever actively induces infringement of a patent shall be liable as an infringer. So the key elements of induced infringement as developed by case law are listed here. There are three of them. First of all, there has to be a direct infringement to have an indirect infringement or inducement. Secondly, there should be knowledge of the patent and infringement by the accused inducer. And in this case, of course, the courts have specified that willful blindness does not absolve the infringer, and they should know, they should have knowledge of the patent in question, and should have known that the actions they induced would constitute infringement. And the third element, which is the most important in this case, because that's the only element that is at issue, is about active inducement, which means an affirmative action or a set of affirmative actions by the accused infringer that encourages or aids another party in infringing the patent. These actions could, for example, be providing instructions or training for or marketing materials that promote the infringing use. These are all important in this case, and have been extensively discussed both during the oral arguments and in the court's opinion. The other thing I want to go over very quickly is the Rule 12b-6, or same, which was mentioned as motion to dismiss. Essentially, this is a motion where the movement asserts that there has been failure to state a claim upon which relief can be granted. The key elements here are, first of all, legal sufficiency. It says the court assumes the factual allegations in the complaints are true, but evaluates whether those facts are sufficient to state a plausible legal claim. Plausible here is a term of art. It's like a level of probability in some sense. You can consider three levels of probability. The lowest is possible. The second is plausible, which is here, and the higher one is probable. And the court mentions that it shouldn't be at the low level of possibility, but it has to be plausible. But again, need not be probable. These are all terms of art, and was discussed in this case again during the oral argument specifically. Well, the movement here, which is almost always the defendant who moves for dismissal, was reminded the only burden, the only level that the case has to clear is a plausibility. And that's essentially what has been argued in this case. And the defendant or movement is saying that the plaintiff has not stated a legally cognizable claim. All right, we go back to, I believe, Joe, you're going to talk about Federal Circuit decision, right?
Yeah, I think the decision is fairly straightforward here. And remember, just to highlight it again, we're at a very early stage in litigation. And so there's been no fact discovery or anything like that. Here, the Federal Circuit actually reversed the district court's decision to dismiss a case. And here again, as Reza just mentioned, it looked at the evidence that was on the record so far, and so basically said that there was a plausible case of infringement, inducing infringement. Basically, I would say the court looked at a couple of things. Number one, it wasn't the label so much that in my opinion, was the issue. I would say that it was more the marketing materials that sort of implied a broader use than what was on the skinny label that Hikma had appropriately produced. But there were marketing materials that went beyond that, basically by saying, constantly calling their version of the drug a, quote, generic version of a CEPA, end quote. So by saying, the court basically found, well, Hikma, you're saying that this is the generic version of the CEPA, so therefore a physician or other medical provider could use this in such a way that you're admitting that, a medical provider could use this in a way that the CEPA can be used. And so therefore, these market materials and the press releases read on using it for both the reducing cardiovascular risk indication as well as using it for the treatment of severe hypertriglyceridemia. And the court has said, the label is relevant, but it's not the only evidence for inducement here because we've actually got, it's different again than an ANDA case, which we'll discuss in a minute, because it's actually on the market. These drugs are both out there, right? We've both got the name brand available and also the generic is also available, which is not the case in an ANDA litigation necessarily. It's usually not. But here, given both the marketing materials and Hikma's characterization of it as a generic version of a CEPA, that looked like it could be. And according to the court, it's plausible that it would induce infringement, and that's why they decided to allow the case to move forward. I think at this point, let's talk about Hatch-Waxman a little bit and ANDA litigation, just briefly, because I think it's relevant. It's interesting to think about. So Hatch-Waxman, of course, back from 1984, it's to encourage innovation and expedite generic drug availability. And there's several key features. One, it returns patent term for the time spent for regulatory approval. It establishes abbreviated new drug application regime and also created the Orange Book. So we'll get into what all those things are. So let's talk about an ANDA new drug abbreviated new drug application or an ANDA. So the generic filer, when they file an ANDA application, can actually rely on the safety and efficacy data of the name brand filing. So an ANDA, a name brand NDA, new drug application, will be thousands and thousands and thousands of pages long. An ANDA will also be several thousands of pages long, but several thousands less because they don't have to show the safety and efficacy data. They really don't have to show the bioequivalence. And if they can show bioequivalence and it's the same compound, then it's assumed that it will have the same safety and efficacy profile of the name brand. And when filing an ANDA, basically it's a lot of timing involved in this. So the FDA grants an exclusivity to the new drug applicant, and they often get what's called a NCE, a new chemical entity exclusivity. And 1 year before the NCE expires, so the so-called NCE -1 date is the date when an ANDA can be filed. The generic manufacturer can file their ANDA. And there's sort of a carrot for the ANDA filers to file on that day because the first ANDA filer can get what's called an 180-day exclusivity. So eventually, when everything gets approved and they can bring it to market, the FDA will only approve one ANDA, the first filers, and they get 180 days of exclusivity, which is obviously worth a lot when you're the first generic on the market for a popular name brand drug. As part of their ANDA, if there's existing patents on the name brand drug, they file what's called a paragraph 4 certification. So that is the ANDA filer has to set forth a factual and legal basis as to why the patents are either not infringed or are invalid or are unenforceable. If the name brand sues within 45 days of that ANDA filing, there's actually a 30-month stay of FDA approval of generic. So that's a way for a carrot for the name brand to file their lawsuit quickly and to get these things resolved in court in as quickly a time as possible. So the carrot for the generic filer is 180-day exclusivity. Sort of the carrot for the name brand filer to file it as quickly as possible is a 30-month stay. The filing of the ANDA is a constructive act of infringement, right? Because there's nothing on the market yet. So it's just the law is set up so that that counts as infringement and can allow the suit to proceed. So what we're talking about with a skinny label is a different regime. So well, within the same regime, but a little bit different. So in paragraph 4 certification, I'm sorry, I skipped something. The Orange Book, the electronic Orange Book. The name brand actually has to list every patent that they consider covers either the name brand product, the drug product itself, the drug substance itself, the drug product, which is the formulation it's in, or methods of using. So they have so-called use codes. And those use codes are the things that end up on the label as sort of the indications, roughly speaking. So so the generic can look and they'll say, all right, Vasipa. They'll go to the Orange Book, punch in Vasipa, see what the name brand patents have been listed against that drug, and they say, okay, these are the ones we have to certify to. Either we're going to wait till this one expires, like the drug substance. A lot of times the generic will wait till that's going to expire because those, they don't want to fight that one. But for the method of use, they may argue that, okay, we don't infringe this or it's invalid. Those are more likely to be challenged. In a skinny label situation like this here, we've got a name brand product with 2 indications on them, only one of which has active patents. The other indication is for the severe hypertriglyceridemia treatment. In a previous litigation, those patents were actually found invalid. So basically Hikma knew that if it could bring to market only on the severe hypertriglyceridemia indication, it wouldn't necessarily get sued under the other patents that cover the CV risk indication. So they made the label and they left out all the parts about the reducing the cardiovascular risk parts and only had the one indication. So that's called a skinny label. And that's not a paragraph 4, right? That's a different code section. It's called section 8. So that's kind of it in a nutshell. And then I think, Reza, there's a case on point here. You want to discuss the GSK versus Teva case?
Yes, Joe. Thank you. So yeah, because this case was mentioned and very much used in the case of GSK was mentioned and used in this case, let's go over it very briefly. GSK v. Teva is a 2020 and 2022 case of Federal Circuit for which the cert was denied in 2024. Here, let's say GSK more or less is the equivalent of Amarin in our case, and Teva is the generic manufacturer in this case. And eventually, Teva was found liable for inducing infringement, although Teva also used a skinny label which excluded the patented use here related to heart failure. And in this case, Federal Circuit reasoned that Teva, in different manners, for example, their marketing materials, press releases, and product catalogs, and the fact that the doctors often prescribe the generic for all the approved uses, effectively encouraged use of the drug for the patented heart failure indication. In this case, they could find intent and knowledge, and also the encouragement came from the steps that Teva took. Essentially, this interpretation narrowed the safe harbor of skinny labeling that Joe mentioned by showing that actions outside the label can still lead to liability. And actually, that was very much relevant to our case, as I think, Joe, you're going to further discuss.
Yeah, I think in this case, it highlights the sort of legal risks that a generic manufacturer takes when they go down this skinny labeling strategy. Even with the carved out label, the generics still may face these induced infringement claims based on their based on their marketing and their marketing claims or press release claims, things like that. So it can be really a challenge. And the other thing is, in an ANDA case, the damages really are injunctions. In situations like this where we have this skinny labeling, the damages are real because there's a generic product on the market, so they can be hit with damages for these patent infringements. So that can be a real challenge as well, which is not something that's generally at issue with the run-of-the-mill ANDA case because the generic manufacturer doesn't have their products on the market yet. Basically they're trying to get the 180-day exclusivity so they can bring it to market and then and get their 180 days of economic benefit for that. So this situation of a skinny label can be fraught. Amarin survived the 12b6 motion, but they haven't necessarily won yet in court. So they're not entitled to their damages at this point. They still have to show that that Hikma was inducing infringement.
So Joe, one of the questions that comes to me is that because this is such an early stage, so it's hard to draw necessarily specific conclusions about what may be permissible and what may not be permissible in terms of marketing. But it seems to me that one way that Hikma could have dealt with it is by disclaiming any use for cardiovascular indication, and they didn't do that. They did not explicitly indicate that it's not meant for cardiovascular, indication. So I'm just wondering what you think the reason was and whether that could have helped them.
I think it's difficult to do that because physicians have the right to prescribe off-label. So even if the generic is going to say, okay, well, don't use it for cardiovascular risk. I mean, the physicians are going to do whatever they're going to do. And so, physicians don't have to worry about infringing patents because there's a safe harbor law regarding their work. So physicians are never at issue here. It's always going to be between the manufacturers. But I think to me, the biggest risk that Hikma took was saying that their compound, their drug, is the generic version of Vascepa. Because when you say it's a generic version of Vascepa, that's going to tell physicians that you can use this for anything you would use Vascepa for. And as to whether that would be enough to overcome, a negative statement like that, like don't use it for cardiovascular risk, I'm not sure. I think, I'm not sure how that would play out. But the fact that they're calling it the generic version of Vascepa, I think, is going to be troublesome for them going forward.
Well, actually, that did come up in the oral arguments. There were a few things, although this is not my area of practice and expertise, but I learned a lot from you, Joe, and from this case. During the arguments, a few things came up. One is that the reason that the additional evidence went against Hikma was what you said, the fact that they mentioned that their generic is the generic version of Vespa with no qualification. And in addition, they mentioned the total sale numbers of Vespa, which actually more than 75% relates to the patented use for cardiovascular. That's what court relied on. And in fact, also it came up that they don't have, apparently generics don't have an affirmative duty of disclaiming the other uses. They're not supposed, they're not, they don't have any duty of discouraging the doctors from using the generic for any use that they may want to. That's not their duty, as came up. And for that reason, Hikma's counsel was saying, look, this is going to be terrible for skinny labels and for generics, because now the brand name manufacturer can just wait, like you said. They don't have to go think about ANDA. They wait until generic comes out, it's used, and then they can file for damages under induced infringement. And it's terrible. And what Chief Judge Moore said, no, that's not the case. All you had to do is in your press releases, you should have avoided, and maybe just have said this drug, generic drug, is what it is confirmed for, what it is approved for. You don't have to say anything more, and that's all. And you didn't do that. And you implied it can be used for all other indications. There is a real thin line that different parties has to walk in these cases, which shows how of course it's lots of money behind it.
Personally, it seems like it makes it more difficult for the generics because now there is a level of uncertainty that depends on the total circumstances of marketing and press releases, and that makes it a lot more complicated because you may be able to find anything in the marketing, and you could argue would encourage inducement of a different indication. So I think it is, in some sense, it's true that if this case goes, I mean, we are still, as we said, at an early stage, but if it follows the same way, it makes it more difficult to have some level of certainty when using skinny labels.
Yeah, I think it'll, the generic manufacturer is really going to have to watch their marketing materials or press releases. I mean, the problem is then you have, basically an army of salespeople out there trying to move product, saying, whatever they want. I mean, so it, like you said, Reza, it's very difficult. Probably the safest thing would be to disclaim the patented use on your marketing materials, your press releases, at least the official things that you have. And then, I don't know what you're going to be able to control the sales folks too much, but yeah, it does raise a lot of danger for the generic manufacturers going forward.
Let's talk about what can happen next. Reza mentioned it. I mean, this is now sent back to district court, of course, because motion to dismissal has been rejected. What would be next, you think?
Well, typically there could be a summary judgment motion at some point.
In which the standard is higher now. And they can also look at the facts. Some of the evidence comes into play.
Yeah, or may not be, but typically there could be, summary judgment motion. And
we'll have some fact discovery in the meanwhile too, and additional fact discovery. So I think, at least with a summary judgment motion, there be some additional materials that the court can look at in order to make the decision.
Yeah, I think it's to me at least, it's not that clear cut. I mean, because for example, the sales figures of Vespa. Well, I mean, it's also used for the other indication. And as, how would I know necessarily what portion of it is directed to cardiovascular or what portion is not? So, I mean, I think these facts are interesting because I think, to me at least, it's gray. It's not that clear cut. And that's maybe why it's sort of the motion to dismiss didn't work because there's a, plausibility level here.
Absolutely. The arguments was to that, towards that as well, that are there any issues of fact here that needs further exploring? And the court decided, yeah, there are. So we can just dismiss it at this level.
Yeah.
Great. Well, thanks so much. It's a great topic and a great discussion. And we'll keep an eye on the case and see how it goes. I think it's a really interesting case. It's going to have all these cases have reverberations throughout, the pharmaceutical industry, both sides, name brands, generics. So these are always very important cases to keep an eye on. So thanks so much.
You.
Thank you. Bye.